I think if we can just sort of unpack a couple of the key issues of concern, which is the encumbrance issue, from what I understand, Councillor Fletcher, maybe just a little bit more before we go to questions, and maybe we might ask Wayne to make some comments of clarification as well. So can we just, seeing we have our legal advisor here?
Yeah, I'd ask Chris Linwood if he could address that.
Thanks, Richard.
Sure. This point was obviously negotiated with Greenfleet, and it is a requirement for them for this transaction to go ahead that the encumbrance is registered against the title. The main reasoning behind the encumbrance is that so purchasers of any land in the future may be aware of the commercial relationship council has with Greenfleet. Encumbrances of these nature are quite common, just talking generally, not with respect to council, but to ensure that those obligations are made aware to future purchasers of the land. And they're quite common to achieve that mechanism. It is basically just notice to the world of the existence of the commercial relationship. There are things that are done through the contractual relationship to ensure that certain rights that would normally be granted to an encumbrancy are minimalised. For example, they don't have any of the powers or the rights that are normally implied under the Property Law Act. And also the rent charge, which is also necessary, is of a nominal nature. So in reality, the obligations of the council are not increased by the granting of the encumbrance, but I obviously do note your concern about it obviously being precedent setting and it being registered against the title to the land.
Madam Chair, I take it then that this is really just part of the negotiation with Greenfleet, and while I was most encouraging as the former chair of the Parks Committee of the relationship with Greenfleet, I think it would, given that it's just symbolism to a degree, I have a real measure of discomfort with this, and I wonder, is this a deal breaker with Greenfleet, or are we getting into a matter of commercial sensitivity?
I think we might, I know there are some other questions, so what we might do is sort of round up the questions, and I am going to ask Mr Wayne Westcott to come and give some comment on behalf of Greenfleet as well. But councillors and members, the key issue for this seems to be finding a legal way to bind this carbon sequestering into a non-negotiable time frame. Otherwise, to be absolutely blunt, we could be getting money paid for trees planted, agreement that we're doing the good thing by the environment, and then quietly having a council, 2 councils from now, chopping the things down and destroying the entire reason for this happening. So it's my understanding is that it's trying to put integrity and transparency into this, and I think when we view it from that perspective, it kind of changes the lens. But the questions you raise are entirely valid, Councillor. Why don't we go around and take the questions, then we'll take a comment from Greenfleet, and then we'll take it from there. So I've got Councillor Casey, Councillor Darby, Councillor Clow.
It's probably not Greenfleet I'd like to speak to. It's more to get some legal advice, because my colleague Mike has gone, but he's very clear that this would compromise the legal order in council, guaranteeing ownership to the people of Auckland in perpetuity. It's never been done before. These are regional parks. It seems too big a step to take, and there's got to be another way, and this is not it. And neither have the Friends of Regional Parks been consulted. In fact, nobody's been consulted. Way too big a step. So that my question would be to get some legal advice about the perpetuity and ownership, and whether it's been compromised by this step.
Sure.
I suspect it is.
So this is the right time to do that. So Richard and Chris, can you feel that?
Madam Chair, if I could start off and then maybe Chris will follow up. The regional parkland is protected in perpetuity under an order in council under section 139 of the Local Government Act, and the areas that are identified for revegetation, which would form part of this agreement with Greenfleet, are all areas that are identified in the Regional Parks Management Plan for revegetation. So they've already been identified to be revegetated in Indigenous forest land, and that would be on a permanent basis, given that protection on that land. So I don't, I think that in itself means that it's low risk, and the community have been consulted through the Regional Parks Management Plan around the areas that have been identified for revegetation purposes.
Okay, and so just the question that Councillor Casey raises about the legal aspect of this, because I guess the lens that can be causing concern to Friends of Regional Park, or, you know, an interpretation of this could be that somehow we're transferring ownership of a portion of our park to a private organisation, and we just need to be able to be really clear that we're transferring the future of the trees that have been planted on that site, and that's the legal type is around what's planted there. We're not transferring land ownership nor the stewardship of those regional parks to anybody else.
That is correct. All the encumbrance is ensuring is that the interest of Greenfleet and the commercial arrangement with council is noted on the title. Just to add to that, we've also ensured through the commercial negotiations, and Greenfleet have accepted this, that where there are any statutory restrictions on the granting of an encumbrance by council, then it will not be required in that instance.
Okay, so let's keep going round. We've got more questions. Councillor Darby.
Yeah, thanks. Look, I'm very interested in this, but I'm also, like many others, just sort of interested in what other instruments are available. So we're looking at a legal instrument. Are there no, have the planning instruments been exhausted and looked at? Are there no possible planning instruments that could be offer the same protections?
I can't speak to the planning instruments, but from a legal perspective, this basically is the only option. Covenants and growths are not registrable in New Zealand, and because Greenfleet don't have any dominant land, we can't do a normal covenant. So that is why an encumbrance is being put forward by Greenfleet, and as I mentioned earlier, it's commonly accepted in these situations that that is the instrument that is used to protect a third party's rights over land.
So no, there's no planning tools at our disposal. That you've exhausted that, you've looked at all those options. That's all I'm wanting to check.
There's no planning tools that provide the level of protection that's been, or advise of the interest that in the same way that, or to satisfy what Greenfleet need from this, as I understand.
Thank you, Councillor Darby. Councillor Clow.
I don't want anyone to throw their laptops at me, but let's say next year when we actually look at the Cameron report again, and one of the suggestions is possibly selling a little bit of land in order to, for example, fund new regional parks. It could be something. What does that mean for anyone who buys a section if we did shave off a little bit of land on a park without ruining the integrity? What does that mean for those owners, those purchasers of a section?
If someone was to purchase a section of land which we have granted Greenfleet certain planting rights, then obviously any purchaser would just be subject to that agreement that we've already reached with Greenfleet. So they would in effect take over council's obligations in respect of that part of the land.
So that means they can still make a clearing for a house subject to all our other rules on coverage and etc.
No, the land, if there'd been trees planted, the new owner of the land would have to obviously comply with the obligations in terms of not touching that planting.
Is that clear,
I
Councillor?
suggest that's a little bit of an issue, I don't know.
If I just add a little bit of this, because we've discussed it a few times, notwithstanding that question, these areas have been identified for revegetation anyway, and the only question remaining is to what degree would they be on the fringes or an area where there might be an interest from third parties, Councillor Clow, and nobody can quite speculate on what that relationship might be, but I suspect the chances of overlap would be low if that was to be the case, given the nature of the reserve management plans that you have in place and where you foresee that planting.
That's correct.
So I guess Councillor Clow's scenario is a two-hoop scenario. Number one, we're re-vegging places that require revegetation. Number two, we are protecting in perpetuity those areas. So if we were going to sell pieces of regional parkland, yes, don't throw laptops, that would be the first hurdle. Secondly, would we necessarily sell the pristine areas that we've put aside for revegetation? I think that, we need to put it in that context.
Yeah, but can I just a little bit of information follow up there, because I have talked to a few people on the committee, supporters of the regional parks, and it is possible could be some land that actually isn't vegetated and is really on the edge and is not very suitable. That could be, possible for sale.
Yeah.
Wash my mouth.
So if you look at the cascade of work, number one, establish which might be not suitable for ongoing role as regional park. Number two, don't revegetate them. Number three, don't make them available to Greenfleet. That's the way around we'd look at it. Yep, okay. Councillor Wayne Walker.
Sure. Just got a question around, I'd suggest, the fairly unique position of the council, and I'm making the assumption, and it's not around throwing laptops around, that we're not going to be selling areas of regional park. So I would have thought, if ever there was an instance where you actually didn't need to have an encumbrance, we would be it, as compared to perhaps some private property or the like. So again, I've just got some questions around exploring this. I'm also enthusiastic about revegetation and planting, and I've got a question around how we would apply this concept to areas of land that are owned by council that aren't regional park, in terms of extending it, and what encumbrances or the like we might need there or not. Because again, I say, I'd suggest our position is quite different to other private landowners. It may be unique. I don't know whether councils in Australia that have regional parks or the like are also doing this. So it would be useful to have that context as well, and for that matter, what is happening elsewhere.
Okay, so a couple of questions there, Councillor Walker. Do you want to make a comment, Richard?
Yes, Madam Chair. I think the original report anticipated this as a bit of a trial to see how the program developed, and so it specifically included regional parkland for that purpose. And we've tried to contemplate in the discussions with Greenfleet applying it, how it might apply more widely to other parkland as well, like local parkland. And but though we haven't had any discussion or conversations with local boards about their reaction to that. And sorry, I've lost the second part of the second question, Madam Chair.
I think it was just applications elsewhere. And that's probably maybe a question for Greenfleet and the wash-up discussion. Councillor Fletcher.
Oh, thank you, Madam Chair. As I foreshadowed before, I think it would be desirable for this to be referred to a small group that could actually examine this. But what we haven't got in the report is any understanding on the timing. You've explained to us very clearly that that is the legal remedy, but there may be other solutions that could be negotiated, but what we don't understand is why you are bringing it to us now. Do we have the luxury of a little bit of time because this is precedent setting, and also because we know that we want to have more partnerships, not fewer partnerships, with the private sector to bring in additional revenue forms? It is really important that we get the framework on this right. So, Richard, can you advise why we need to take a decision on this today? And would the process benefit from actually taking a step back, getting a working party to look at those issues around partnership for the future and the parameters and the philosophy that we want to apply on these sorts of things?
Thank you, Madam Chair. Through you, Madam Chair. I think the reason for trying to bring it to a conclusion is that we've had this process now in negotiation and trying to move it ahead over the last 12 months, and it's taken us all that time to get to where we are now, where we have basically reached agreement on all the other matters, and so this is the final matter to be resolved. Greenfleet obviously are very keen to establish in New Zealand and get things underway here, and I guess others are waiting to see how we proceed with this. But Wayne Westcott may be able to comment more about what others are doing in this space.
Thank you for that, Richard. Madam Chair, I am very supportive of Greenfleet, and I'm very supportive of our staff around the council table who understand that we need to bring in new revenue to be able to achieve some of these big aspirational goals that we've got for our regional park.